Welcome to Docket Decoder. If you enjoy our content, please help us out by hitting that like button or leaving your comments for us. And don't forget to subscribe to stay up to date with the latest court filings.
Opinion. Let's address what I have is to be the last item, which is the motion to strike the death penalty regarding discovery.
Your Honor, we are asking the court to strike the death penalty as well as issue some additional rulings in this case as it relates to the discovery issues. Your Honor, we're asking the court to look at this not as a Brady violation, but as a due process violation. And it's important to understand a little bit more about the discovery to do that. First, I'll start with defense counsel's obligation. In any case, defense counsel has the obligation to meet its constitutional requirements of effective assistance of counsel, and that means that we have a duty to investigate any of the state's claims and review the state's discovery. There's a heightened sense of that responsibility in a capital case. Death is different. That's been said time and time again throughout the United States and state courts as well. So we need to be able to review all of the discovery. We need to meet that obligation, and we cannot. 68 terabytes in our briefing. I won't repeat it all here, but
I don't have a clue of what's in there in some senses, because I don't know how much of that is music, how much of that is video and movies off personal devices, how much of that is things that no reason to look at.
Well, the problem is, Your Honor, there is a reason to look at it. There are tons and tons.
Why didn't you bring a motion earlier asking for intervention to have me do other things, and rather waiting to tie it to the death penalty at the end?
I'd say that's a bit of a mischaracterization of what's happened.
The first time we met, you told me about having received the state's discovery and the number of terabytes. And the first question I asked you was, have you looked at it? And you said no, you hadn't yet looked at it. And we talked about the trial date, and I moved the trial date back a little bit for that. And I haven't heard a word since then that you haven't had enough opportunity to review the discovery or to do the discovery.
Well, I'm here to tell you now that we haven't reviewed all of the discovery. Over the course of the case, there have been multiple emails and letters back and forth with counsel about discovery. We've had motions to compel discovery. When I first met you, I was very candid with you about the size of discovery and that our team had not looked at it all. Since that time, we've continued to receive additional discovery. And probably most importantly, that brings us to now. Why now? I think that's a fair question. Since we began with the expert disclosures, and I'm not going to go all the way back through that, I talked about that exhaustively, but that was a real turning point for us, that when you're moving along with a schedule and a pace, in this case, especially with the sizable amount of discovery, and I want to tell you what's in there in just a second too, but we're moving along at a specific pace, and the expert disclosures, we've talked a lot about that, and those were not adequate. The court told the state to do a better job. We've talked exhaustively about that, but that disrupts the flow of everything that we're doing when that happens. We had worked diligently to get motions filed and to get our other motions that were being heard in January prepared and to meet our expert disclosure. And now in the time since January 24th, we've had repeated meetings with experts with new information here to find out what it means, new information there to find out what it means. And it just hasn't allowed for enough time to focus on the discovery. And that's not all. We have these motions in limine. We've talked quite a bit about the dollhouse and the issues with the dollhouse. That takes time. Everything like that takes chunks of our time. We don't have all the discovery reviewed. That discovery consists of thousands and thousands and thousands of pages of police reports. I know the court has a little bit of a glimpse of that. The court asked the state to give them Detective Mowry's police reports that he authored. I think it took him 10 days to get them all gathered up to the court. That's one officer. That's just one officer. We have, I think, over 15,000 photographs.
4 years in the fall,
No,
the homicide.
no. It's 3 years in the fall since the homicide. Mr. Kohberger was arrested.
Fall of 26 is what I was referring to. So 3.5 years.
The homicides happened in 2022, November. So we
2026
are
November.
2.5 years since that happened. We're in 2025. Would be 3 years in November of 2025.
Happened in November of 2022. Oh, you're right. Never mind.
It's been a long day, Your Honor.
It's been a long day. I'm off by a year, and I feel a lot older than that, than having aged more than just a year in this hearing. But regardless, at what point are you ready? Does that mean that in no case where there's a lot of data, can we have the death penalty?
Your Honor, that
You've gone a new death penalty case since you came onto this case. Why would you do that if you were not having enough time on this case?
Well, Your Honor, when I agreed to take that case, we had a certain pace going in this case already. And then things have happened since that point in time in this case that have set us back.
The skeptic would look at this and say, well, this is what Judge Boyce did when there was a last minute discovery issue. This isn't a last minute discovery issue. And it seems like this could be viewed as being calculated to try to be a method to get the death penalty off the table by waiting until the end to bring to the court's attention the contention that you can't get through all the discovery.
I'd ask you to look at the things that have happened since I would say our status conference, the first time we met when I was hopeful that we could get through a number of the things that we still had left to do. There are things that have occurred that have taken an extraordinary amount of time. There are a lot of things that we haven't had a chance to look at yet. We continue to go through discovery as rapidly as we can. We're just not going to get through all of it by the time we get to trial. Part of that is the way that it's organized, and that's why part of our request is to have the state give us the documents they rely on. And
with giving hot documents is if they don't point out a document that you later say, oh, we should have known about that one. Now somehow they're culpable for not seeing the document the same way you did. And so that's why courts are very hesitant to employ that remedy, because it makes the state kind of do your job for you.
Your Honor, I would let the court know how we've received discovery in this case. And this has been a topic between counsel since the initiation of the case. The discovery goes to the police department, and then sometime later, the state gets it, and then they get it to us. So there's a delay already, but the documents don't come in any organized fashion. When you received all of Detective Mowry's police reports, those would have been scattered over probably a year for us to get. We litigated the video, 1112 King video. We litigated that for about a year before we got the full copy of that. Those are all things that take time, and we are now months before trial with the cumulative effect of what's happened. And we now are faced with the issues with expert disclosures. Hearing the state today, I don't expect they're done trickling in expert disclosure after expert disclosure. At what point is it enough when we can be counting on that's it, we can get ready? The court's discovery deadline came and went. A lot of additional discovery has come past that deadline. At what point is that enough? I'm picking up more discovery today if I can meet up with the prosecutor.
Is it a penalty-based discovery?
I don't know. I haven't seen it
That's
yet.
part of my problem is I don't know, because you're very vague about what it is you haven't been able to do.
Well, let me tell you then. There is surveillance video from all of the university, all of U of I, and there's probably some pretty critical places where that discovery or where that video exists. I haven't watched that. I've sat down to watch it on several different occasions, and other team members have sat down to watch parts of it too, to try to see what's there. The way we've received it, it's not labeled in any fashion at all. I can open up a folder and I can look at something and figure out what date and time that's from. And there's multiple cameras and multiple days. There's no index, there's no guide to what it is. So I haven't looked at all of that. There's a couple of additional video footages that I haven't looked at. Now, if we want to start talking about cell phone data and third-party digital data, I have an expert who said it would take 3 years for him, an expert who knows how to do this, to go through every single piece of that. Now, he's been through a lot because we've had a little bit over 2 years to work on that. Not a full 2 years because we haven't had that discovery for the full 2 years. But there's quite a bit that I haven't looked at. I don't have an expert giving me even a report. We're not completed with that. I think I've read most of the police reports in this case, but I haven't read the thousands and thousands and thousands of tips that came in on this case. Don't think they're all not relevant, though. Recently, we came across a tip just in trying to work through some of these issues. We came across a tip that would appear to be an alternate suspect, and we're trying to work through that as rapidly as we can. It was quite a surprise to come up with that. There's got to be more in there that I need to know. We were disclosed a bunch of email communication between different law enforcement officers, different lab personnel. I probably have read about half of those by now, and different parts of our team have read different parts of it, but we don't have it completed yet. Those are some quick examples that I can give you. I've looked at every picture, and I believe I've read every police report. There's a lot left to do that could have things that are favorable to Mr. Kohberger. In January, I had to stop doing that because I had to start worrying about the expert disclosures that we didn't get. I continued that through February. We've responded to the motions in limine. We've responded to the dollhouse. We've met our deadline with our mitigation experts. We're meeting the deadlines that are set out, but there's only 24 hours in a day. This is what's happened here is not satisfactory. That the discovery is not in an organized fashion. It's not in a searchable fashion. We've encountered documents that have been locked, most critically the entire DeSales record for Mr. Kohberger's education at the DeSales University. Those were locked documents. They were a complete mess. It took one of our team members probably 10 days to get them in an organized fashion where we could understand what document went with what other type of classroom or assignment or other event. I will tell you about the motion in limine we didn't discuss today, the self-authenticating records. When we received the state's initial list, these are the list of things that we want to put in with a certificate. We went through those discovery folders, and those didn't contain just one document. They didn't even contain a document that made sense about what the state was trying to do. That took me personally about 10 hours to go through all of those folders of discovery so that I could write a response to that. The state replied, abandoning wanting to use about half of those right out of the gate after I'd spent the 10 hours. And we come today prepared that the court was 100% right. Those pleadings weren't ready. There's not a packet with a certificate of authenticity for the court to make a decision on. The court was right. But that doesn't mean that I can't be prepared. Those things take time. And when we're talking about the amount of discovery that's left outstanding, everything that happens like that eats up those minutes. In this situation, Your Honor, it's not that we saw what Judge Boyce did in Vallow and thought this is a great idea. We are at the end of our rope doing everything we can. And I know about what Judge Boyce did. And I have to come to you and say, you need to do this too. This impacts Mr. Kohberger. I can't not bring this motion because somebody might think I was waiting to the last minute. I can tell you we weren't. We weren't. We've been working as diligently as we possibly can work on this case. We have understood the court's...
Have you gone to Judge Monson to ask for additional resources?
Well, Your Honor, we do have an additional resource. We recently added our attorney, Ms. Barlow, to,
A team of another 5 or 6 paralegals, for example, to go through stuff.
I can definitely do that. I don't know how that puts the information in my head fast enough, but I can
That's the
definitely do
point
that.
of having litigated many very large cases, you have staff that tell you, here's an important document. And then that one comes to your attention from the, as you pointed out, the gigabyte or terabytes of probably pointless video cameras that nobody's ever going to rely on, that don't show a thing.
If I'd had a team of 5 more paralegals that understood the case already, that would be one thing. I certainly can ask Judge Monson for additional resources. I certainly can try to get somebody to understand what the issues are. I don't have a problem doing that, but that doesn't change where we are now. That doesn't change the things that have come up that have impacted our ability to prepare. I understand that the court has said this is the trial date, it's carved in stone, and I've done my best to adhere to it, and I'm here now saying that the death penalty needs to be struck so that there's fairness to Mr. Kohberger. The remedies for the court are to strike the death penalty and to have the state give us a list of Brady documents and the documents that they want to rely on. This is a huge amount of discovery, and we don't have the same resources of the state.
I'm going to get a list of the documents here in terms of exhibits in the next few days, I would imagine. I'm not sure. April what is that date?
Well, it's just a little over a week away. Ours are due the same day.
Well, but if there's things on there that you didn't anticipate. This is a process where there's the ability to add things by your part if there's things that you didn't add, if you discover something else in there. But the point is, you will know generally the universe of documents that the state's going to rely on in 2 weeks.
I will know those. I will know those. And when I produce mine, the state will know what I can rely on, but I don't know what I don't know yet.
It sounds like you would never know what you don't know, given what you've told me. It's going to take, 18 billion years to get through.
Well, I don't think it'll take 18 billion years, Your Honor. I think that
Well, it was several decades, as I recall, is what you'd said, or several hundred years.
I can promise you I won't take several hundred years, but
You see my point? That's what you said it would take to get through that, an individual. I have a hard time taking that at face value because that's not a realistic answer.
my realistic answer, Your Honor, is that we were working, and we still are working diligently, but the discovery was one of the biggest things that we were doing methodically, going through that discovery so that we could understand everything that the state had given us, even in its disorganized fashion. And that changed with the things that have come up over the last few months. Our entire plan, our schedule has changed to be responsive to everything else. And that's not Mr. Kohberger's fault.
Complex litigation generally, when you're in the expert phase. I mean, that's not unusual.
I guess, Your Honor, I think it's unusual when deadlines are blown by the state or not adhered to by the state, and our client pays the price for that. So I do think it's unusual. I think it's unusual to receive discovery where you might get 23 pages of a transcript, and then 4 weeks later, you get the rest of that transcript. We have had to match up discovery every step of the way. I don't think that's usual. I think there are things that have occurred in the path of discovery that are not usual at all. And I think things that have happened.
I guess my point is if the discovery is being provided in that way, this is something I should have heard about in September.
I advised the court that we were not through.
You had not yet gotten through things, but you didn't advise that the pattern of the way you're getting discovery in terms of, incomplete here and incomplete there, et cetera. That's all new.
I agree that that's new to Your Honor. I know that we discussed a sizable amount of recent discovery we had gotten. Those issues came up prior to this court taking the case over. We had talked about the way discovery was being received early on in the case. We filed discovery request after discovery request, in addition to talking about the mismatched way discovery was received. That has been put on the record. My hope was with the state's discovery deadline, with that cutoff date, that we'd be able to pull it together. My hope has been that until these new things have happened to shift us off the course that we were on. And I'm here to tell you about it today. I think it would be a lot worse if I stood up at jury trial and you said, is the defense ready? And I said, no, we haven't read all the discovery. So this is my opportunity.
Right, that would make me happy.
This is my opportunity to let you know. We filed this motion several weeks ago. So the prosecutor and the court's been advised. We have been diligently trying to get through it all. We can't. It wouldn't matter if I had 10 more people right now, given the shortness of time with that. But I know that there are remedies the court can take. I understand I'm going to get their exhibit list. The court can order them to tell us what are the hot documents, where are the Brady issues. It's not enough just to give it to us in this volume of discovery. We need it identified, especially given the short time. But our position is that the court should strike the death penalty in this case. It will take the heightened level of pressure down, and it will allow us to focus on the trial phase only rather than the mitigation phase as well. There is precedent in Idaho. The court knows.
Circumstances were completely different, counsel.
I'm not saying our circumstances are identical, but it's a due process issue, just like was analyzed in the Vallow case. That was analyzed as a due process issue because counsel didn't have the opportunity to be prepared. And that was grounded in other case law. That was Riviera versus Clemente, Grover versus Florida, and Lopez versus Matthews. And those apply now. We do not have an opportunity to meet the state's discovery, even though we've diligently been trying to do so. And this is the appropriate remedy. And we're asking the court to make the orders for the court for the state's disclosures and to strike death.
Judge, in this case, the state has made every attempt to try to comply with Rule 16. 7 days after defense counsel entered her notice of appearance, she indicated she wanted everything that we had. And we started the discovery process. This was continued routinely throughout this case. Generally, documents such as police reports, lab reports, et cetera, were bait stamped and then turned over, and essentially turned over in the same way that we received them, in the same order as they were done and turned over by various investigating officers or whoever. We put a bait stamp on them. Photographs were done in the same fashion. Larger files, and I could say that, for example, most of the files that come from the FBI tend to be larger files that can contain a multitude of different things. Those were placed in an AV folder and discovered.
Were they meaningfully indexed?
I can tell you for FBI documents, the defense was provided essentially an index for all FBI documents because they requested everything that was on a shared drive for the FBI, and that was turned over with a searchable index.
Mention a problem because of the password protection of documents.
Yes, and we addressed that. Actually, we first heard of that in, I believe, April of 2023, and Mr. Thompson wrote a letter to Ms. Taylor saying that he understood that some of the PDFs were locked, but advised counsel they could get around password protection by hitting print to PDF and then saving, and that allowed those documents to be searchable. They were advised of this over 2 years ago. It's true there's a large amount of discovery. There was a 6-week-long investigation prior to a substantiated tip that led to Mr. Kohberger's arrest. So yes, there was a massive amount of discovery. We extracted cell phones for anyone that had any kind of connection to the victims. We gathered surveillance video for weeks, if not months, of random places throughout Moscow trying to figure out what happened. So to answer your question, there's a ton of discovery, and the majority of it is completely irrelevant.
Are you aware of any Brady information that is in the the cameras that are not the ones listed in your route of travel? And
No, Your Honor, I am not aware of any Brady material, any exculpatory material that's within those videos. The defense is right. All discovery was routed through MPD. We have a central location for collecting all the evidence, all the information, and then it was sent to our office. And then it was primarily reviewed by myself and Mr. Thompson, given approval, and then immediately sent over to defense. Files were kept in the same way by our office as we've discovered. That's how they've been maintained. And the parties are just on equal footing in this regard. Defendant's motion is just replete with these mischaracterizations and just completely false assumptions. For example, they say that there's so many investigators involved on this case. While that might be true that there were many investigators involved on the investigation, those investigators don't help us in the administrative task of organizing and sending out discovery. Further, we do have a PBK case management system, but it is not at all the way that it is described in the defendant's motion. For example, we don't have this global search function. We don't have the ability to just generate reports based off of witnesses. Agencies can't just directly upload into our system. We just don't have that capability. The reality is we rely on a self-created spreadsheet. Throughout the case, defendant has filed over 20 separate requests for discovery. There's been 400 itemized requests for different items, and the state hasn't just simply responded with whether or not we complied. We directed them specifically to where they could find that specific item, if it existed, the location, the description, and the date that it was discovered. I would just go back to that massive dump that we were talking about of the 50 terabytes of data. Defense has had that for over 2 years. It's hard to, I guess, rebut a lot of the allegations because there's no specifics. They just talk in these general terms about all of this data, and I'm not totally sure how to respond other than we've given over the data as we've received it. And they've had the majority of it for several years. Most importantly, defendant has not specifically pointed to any particular piece of evidence that has been withheld or any actual prejudice suffered, and instead just points to the vast amount of discovery, which we have absolutely no control over. The state has in good faith complied with our discovery obligations, and there's just simply no basis for a sanction. And so we had asked this court to deny their motion. Thank you.
This motion is not about withheld discovery. This motion is about discovery in the format it's in, the vast amount of it, and what's happened over the last few months that have taken us off track and our inability to be prepared. And that remains true. The 50 terabyte server that we received sometime in April of 2023 is the one that contains the U of I footage, and it contains a lot of footage around the town. We have been able to go through most of the footage other than the U of I. When the court asked the prosecutor,
Counsel, is there any known Brady material in the U of I surveillance cameras?
Not to the state's knowledge.
Your Honor, I think you'd have to watch that at various relevant times to know if there is or not. I think when you're thinking about Brady material, when we're thinking about video surveillance, and we'll go back to what we talked about the vehicle before and how Special Agent Immel's going to testify, there very likely are vehicles, light in color, white or silver, on all kinds of different cameras. Those could be Brady depending on what he has to say, but they should certainly be looked at. We're trying to look at that as quickly as we can to understand that. We've watched a lot of the video that's contained on that server. Also on that server are vast amounts of bank records, vast amounts of cell phone for all of the people that Ms. Jennings mentioned, the deceased and people close to them and other people.
They've indicated that their experts have examined that and found no connection between Mr. Kohberger and the decedents.
I'm grateful to have recently learned that. I mean, that's what we believed, but that was in that March disclosure when they said that they'd examined those, and those were computers, the 7 computers, I believe. It's that kind of thing that takes a lot of time. In addition to that server, there's all of the other information that comes in different ways. I'll give you an example of the delay. We received a lab report that was dated March 30th. The state received it March 30th, and this wasn't this year. This was obviously not this year. It wasn't even last year. We didn't receive it until May 8th. So the delay going from Moscow Police Department getting it, the prosecutor getting it, to getting it into our hands, that's well over a month. That's a long time for delay for the routing process. I think it's important to realize that the FBI index we have, you can't push a link and get to the document, but I do at least have that index. When we're talking about locked documents, the print to PDF, that's the problem. That's the steps, the additional steps that it takes when we're talking about thousands upon thousands of pages of documents. I think it's hard to imagine that there's not material somewhere in there that isn't favorable to the defense in some way. We recently found that, and we found a pretty good lead that we're trying to follow up on. And that is really what it comes down to. This is not organized data. It's not easy to go through. We've made substantial steps. Due process requires that something be done, and striking the death penalty is the thing that must be done.
All right, well, I will take help to review file. Number one. Number two, with respect to the witness, with the exhibit list. Now, I will say the exhibit lists need to be specific and detailed, not Exhibit 3 video, not Exhibit 3 video from X Bank. It's Exhibit 3 video from X Bank, minutes 25 through 27. Detailed, specific. I would also look at as a issue whether it might be appropriate to require the state to certify that it is unaware of any exculpatory material that it views as exculpatory, that it would, for example, feel it would have the obligation to bring forward if the defense were unaware of it, that has not been identified by the defense throughout the motion practice and discovery and their exhibits and witnesses, et cetera. But I will look at the issue and issue a written opinion on the matter, because I think obviously at a minimum for appellate purposes, you'll want that. So with that, I don't believe we have any other motions to take up today. Did I miss any?
Your Honor, we wanted to approach the court in regard to the review of the jury questionnaire and whether that can be conducted remotely, and when the court would like to do that.
Yeah, so I haven't had a chance to look through your responses to my proposed jury questionnaire. I will do that. Keep that just as a tentative. We can do it by Zoom or WebEx or something like that remotely. There's no need to travel down here to do that. And it may be that I simply just need more time, and we'll tell you, let's take it up at the pretrial conference. I think we'll have time if we get it done at that time. So
Thank you, sir.
I didn't anticipate that I would actually get to the point where I would have given you my draft of what I think it ought to look like by this deadline. So that's part of the reason I had calendared it. So.
And I can tell you, we very much appreciate that the court was able to provide us with your draft, because I think that simplified the issues. And as you review them, they're just a handful of things that are potentially in dispute.
All right. Anything else from defense?
Your Honor, with regards to the exhibits, because they're now scheduled to be due the same day, we'd actually like to see if we could have an additional week.
I will give you additional 1 week after the state's exhibits are due.
Thank you.
All right. I think with that, we are adjourned. Thank you.